Well, in drafting a pre-qualification questionnaire, the awarding authority has to have a very good understanding of the entirety of its needs and the duration of the period over which it needs to have service providers. So it needs to make sure that it accommodates all of the requirements while not duplicating the supplier criteria with the award criteria, because it was found in one case that in doing so, that was a breach of EC law. In Ireland, the Freedom of Information Act can be a very valuable tool for an unhappy service provider, because it's another avenue by which it could find out the reasons why it didn't win the tender, and perhaps find out some more information about who did win the tender and on what basis. One of the difficulties about it is that the time periods under the Freedom of Information Act are quite long, and sometimes there isn't enough time to take an action because so much time has elapsed. But what's also valuable about the Freedom of Information Act as an avenue is that it's another additional way of putting pressure on awarding authority to disclose information. Normally, awarding authorities have some degree of reluctance to disclose who has won the tender on what basis. So this is a second route for putting pressure on the awarding authorities, and in some cases it's quite a successful way of making the awarding authority come to a meeting to tell the service provider why they haven't won.